Hello dear students, how are you? In my last video, I completed some of the very important topic of agency, which are very important for your examination and to understand some important points of agency. In today's video, we were going to start with a fresh new act, that is Specific Relief Act. This is an introduction part of Specific Relief Act, in which I am going to tell you the historical aspect of a Specific Relief Act, the objectives of it, the essentials of Specific Relief Act, and also I am going to give you the brief introduction about this act. For any remedy under mercantile law, firstly, we refer to all the acts related to that mercantile laws, that is Contract Act, Sales of Goods Act, Partnership Act, and Companies Act. And in that mercantile law, there is one special law, that is Specific Relief Act. If a party breaches a contract, and by that breach of contract, if another party got some damages, then that party can sue the wrongdoer party in the court of law for the damages. But this has happened in Contract Act, what we studied. But there is one special law made in regard of some specific relief which are going to be provided by the court when party files the case for that specific kind of relief. There are lot of reliefs like declaration, injunction, and many other reliefs in the Specific Relief Act. And for getting those particular kind of relief, the party moves in the court of law under Specific Relief Act. We were going to study those important relief along with the 2018 Amendment Act. So let's start. As you see that this act is called the Specific Relief Act made in 1963. Specific, we know specific means the particular thing. Relief means make the good the loss. Whatever the loss suffered by the other party, for that loss, the party goes to the court for particular relief. So what kind of relief given in this Specific Relief Act, we were going to study in further videos in further. Firstly, we have to see the historical aspect of this particular act. This act, as you know, it is Specific Relief Act 1963, made in the year 1963, and this is 47 of 1963. That in the year 1963, this is the 47th number act. If we go to the historical aspect of this act, we see that earlier it was Specific Relief Act 1877, which is applicable in India. And as you know, 1877 it is clear that this law was made by Britishes for us. That act have some drawbacks in it. That act have some applicability also, but drawbacks. As we all know that at that time India was not so much organized civil laws. some civil laws applicable to some areas, or some areas have their own particular civil laws. So because of these problems, this act have very less scope, not a wider scope. The first drawback of this act is scope is not wide that much. Scope was not that much wider. Second drawback was that that law was not exhaustive in nature. It does not cover all the points which the present act covers. Third drawback is that it having a great number of lacuna, great number of drawbacks, that it does not, it is silent on some points, that the old act does not talk about declaration, that old act does not talk about injunction or many other kind of relief which the new act covers in it. So it is the requirement for India that to make a new specific relief act. So efforts were made in the first law commission itself. Actually, the first law commission was made in 1854, headed by the Lord Macaulay. But I'm not talking about that law commission, because that law commission was made before independence. I'm talking about the first law commission after independence. After independence, first law commission was made in 1958, headed by MC Sitalwad. In that first law commission, the 9th report of that first law commission talks about specific relief act, the requirement to make the specific relief act for India. In furtherance of that, the bill was introduced on 23rd December 1960 in Parliament regarding to make the specific relief act. But unfortunately, that bill was lapsed. Again, in the year 1962, the bill was again introduced in the Parliament. And at that time, the bill was passed by the Parliament. Afterwards, the Specific Relief Act 1963 was enacted, date of enactment, that it was completed on 13 December 1963. And the date of enforcement is 1st March 1964. That date of enforcement and the date of enactment is important for you. And these are the dates of enforcement and enactment. And we got the new law. Amendment that was made in the new law were made in 1964 itself, the very next year, and also in 1974, in which section 43 and 48, in which the section 43 and 44 was repealed. Afterwards, in the year 2018, latestly, this specific relief, there is a huge amendment in this specific relief act. We were going to deal with according to new law, in which the latest amendment, in which the amendments were made in section 6, section 10, section 11, section 14, 15, 16, 19, 20, 21, 25, 41, and also the new schedule. One schedule is also added to this specific relief act, which we were going to study in future. So this is the historical aspect of specific relief act. Now we were going to study about the objective of this act. In the objective of a specific relief act, we were going to see that there are two main objectives of specific relief act. Basically, the objective of specific relief act, we can find that objective from its preamble. And I'm going to read the preamble. According to the bare language, the preamble of Specific Relief Act 1963 talks, and I quote, an act to define and amend the law relating to certain kinds of specific relief. We see that it is an act to define and amend the law relating to certain kinds of specific relief. So we find the first objective as it is. this act is to define and amend the law. Firstly, this act define this, what is the specific relief, and amend the old law that was of 1877, the law relating to certain kinds of specific relief. So first objective we found from the preamble of this act. And the second objective of this act is to get the speedy remedy. We all know that in the court of law, in the civil matters, basically the main problem is that the people does not get the speedy remedy. So this special law is made for certain kind of specific relief to get speedy remedy in the court. For that particular kind of relief, the person can go in the court under Specific Relief Act and get the relief in stipulated time as given in this act only. Further, we are going to see what are the essentials of this act. Under the essential of this act, we'll see that first of all, this act is a procedural law. It is a procedural law. So you know the difference between procedural law and the substantive law. It is not a substantive law but a procedural law. But at some place it is substantive also. So it is both mixture of substantive procedural law. But if the question asked from you that Specific Relief Act is a procedural or substantive law, you have to mark the procedural law. It is basically a procedural law. Secondly, it is equitable in nature. That the principle of natural justice, equity, it is following the equitable in nature. So second essential of SRA is equity, it is equitable in nature. Third essential is that it is not a general law but a special law. The special law to give certain kind of relief which were discussed in that act, certain kind of relief, and that is why it is called special law. Next, this act is discretionary in nature. Now this question is very important. This point is very important. Discretionary in nature. What is the meaning of discretionary in nature? Discretionary in nature means that in this particular act, the court have a discretion to give the relief, the special relief provided under this act, or a adequate compensation. The person in this act went to the court and asked for some relief, and on the basis of it is a discretionary power to the court in this act, given that the court may give special relief, may give that special relief and compel the other party to perform that relief specially, or provide the adequate compensation after referring the Specific Relief Act. So it's a discretionary in nature. The court given the discretion to provide this relief, but that discretion must not be exercised by the court arbitrarily. Next, we were going to see there is two important maxims for this. So there is one important maxim under this Specific Relief Act which you must remember, that equity acts in persona. Equity acts in persona. It means that whoever is in need must come forward for relief. Whoever is in need must come forward for relief, or equity helps the vigilant and not the dormant. So these are the two important points for this act, that equity helps in this, as we see that under the essentials of Specific Relief Act, one of the essential is that it is equitable in nature. So equity performs when the person is vigilant about his rights, about this act, about whatever the relief provided under this act. vigilant and not the dormant. In this act, we are going to see that a person for a particular kind of relief can go in another act also in the court. But if he is aware about his right under this act, then he can come to get the specific particular kind of relief under this act. Further, we were going to see the all kind of relief, and I'm going to cover the whole of this act in a one diagram, in which I'm going to tell you about what kind of relief is provided under this specific relief act. And in further videos, I'm going to tell you that the about one by one about those relief.